sum up. In Javed's case, they said that Islam protects plurality of knowledge. So any legislation which hits that belief should be declared as unconstitutional. Supreme Court said no, it comes in. Ismail Faruqi, Babri Masjid demolition case, was the case notes where the mosque was demolished, the government acquired the entire area by special legislation. Apart from other grounds, one of the grounds which they raised was it forms fundamental principle of Islam to pray in mosque. The acquisition of mosque takes away this essential principle itself. Essential practice of praying in a mosque, that was negative. I'll show how their lordships construed the problem. Maharashtra was not Islamic. But then what's Shairavan, of course. Where apart from others, there is a Mr. Kamath said that no, they never consider it Quran. No, I'll show you. They assume it is part of Quran. In fact, they assume it as part of Quran and say that yet so we cannot declare it as part of essential practice. We cannot declare it as an essential practice of Islam. These are the 4 judgments which would show. But 5th one, interestingly, I was associated, so I must say that's something which arose in Karnataka High Court, where there is a very popular hotel in Bangalore known as ITC Windsor Manor, still there. There, the land belonged to the Waqf Board, and it was leased out in favor of a particular company. The lease was challenged, but on the ground, one of the grounds was, apart from other things, that the hotel would serve wine and pork, which is considered as haram in Islam. Therefore, the lease itself must be negative. In a reported judgment of the year 1981, Justice K. Swami, as he then was, said no, it can't be considered. These are all instances, of course, on different aspects the matter is still pending, but these were words where on an examination, Lordship will say it's not for the first time that a challenge is made before the court that something should be considered essential. In fact, a number of other instances. I only
case which G. Ramaswamy.
Yes, England. Yes, absolutely. He went to Oxford University. The Honorable Chief Justice G. Ramaswamy is appearing for
to London to study Islam.
He went to Oxford University to study the concept of Quran, to understand whether wine and pork, and of course, by his own inimitable style, he made an analysis saying that no, it does not suit. Finally, it was argued by Paliyastan in the final. That's how this law I will be in a position to show you. So this is not something which has come up for the first time. If Lordships going back to the government order, if Lordships settles this position of law, in one way or other, if it is held that hijab forms part of essential religious practice and passes those 4 tests, and schools cannot prevent it, and our government order automatically will not happen. If Lordships hold other way, then other considerations will come, which I will submit. Yes. The 2 other aspects I must mention. Mr. Tahir.
Yes.
Lordship said. Mr. Tahir Mohammed Tahir had made a grievance before your Lordship about some amount of excesses practiced by authorities, and he gave a letter to me this morning at 10:30 addressing the grievance. But I have already communicated to the Chief Secretary by way of a letter, and I've asked him to convene a meeting of all concerned, if possible today or first thing in the morning, to address all the grievances. How they would resolve it, I will communicate it to him. But rest assured, I have orally spoken to the Principal Secretary to Education Department and others. They have assured that nothing of this sort will be repeated. But whatever action taken by all the officials under the chairmanship of Chief Secretary would be reported to Lordship as well as to my management. Let him be rest assured as to nothing untoward would happen.
My Lord, I may be given a chance, my Lord, because I would like to reply. Your Lordship, I am insofar as the Islamic jurisprudence is concerned, and the judgments is cited, your Lordship may give me time first. I shall be grateful for that. Because there are very important issues, my Lord, which have been raised. So far as, my Lord, essential practice, religious practice, I can give the reply to my friend, citing, my Lord, the Quran verses to your Lordship. and making the position to clear, my lord, how it is essential, my lord, religious practice. Because we are deriving it from the Quran. Verses are there. Actually, give me time first.
Let's let them.
Otherwise, it will result in travesty of justice, my lord. Because
Mr. Dar,
doctrine, jurisprudence of
Mr. Dar.
Islamic law is very essential.
Mr. Dar, in which case you are appearing?
My lord, I am appearing in. That's why I am giving your lordship's trouble, because certain points are very important so far as
This is
3923.
platform where this is not a public platform where anybody can stand up and start speaking.
No, my lord, I am there.
We
for
are in the
5 days.
mid of the proceedings of a particular case.
My lord,
Just
that's correct.
Union Advocate General is addressing the court. How you are
After-
interfering in between?
No, my lord, I am just making a submission that I may be heard in 3923
Don't
matters.
make
Because
submission. No, there is no time. There is no time to make any submission.
Actually, one submission I want to make. In the connected matter, I filed a memo. They said that we also lodged a complaint with the Child Rights Commission. What they are saying is that they will be asked to remove and in front of the teachers, male teachers. So we are given a complaint. Some clarification has been issued today. It seems that letter advocate general can look into it. The copy is also served on them. Because right in front of some people, they are asked to remove the hijab as well as sometimes if they wear the burqa. Some place, separate place, if it is given and then not at the entrance of the gate. This is what we made a request to the Child Rights Commission also. So
Consider
today they
the
have clarified
application.
it, even the inform the TV channel also how they are going inside. The TV channel are going inside and focusing all these things. It is clearly abuse of trade rights.
You go and argue before the TV channel only.
That's why. That's why. Today, no, they have given a clarification. The Child Rights Commission chairman has given a clarification today. It has come in paper today. So my advocate general look into this because it's clearly a violation of the child rights. So maybe they would have gone wearing hijab and whatever it is there. It cannot be in the open place.
But one other
It cannot be done.
One other aspect.
And teachers have been asked to remove the hijab.
Said that.
Whatever is there, we will take care. Rest assured. It can't be, but I am. We will definitely look.
I am not. I am just bring
We are
the
sensitive to it, but we are not. Some government which is very sensitive. But that government order of 2014 Lordships wanted to.
Circular.
That has received the approval of the minister. But I am placing that file before you. It has received the approval of the minister. We'll place
All
the-
right. If you say that, we believe it.
No, yes, I can also place the photocopy of that along with the memo. We have it. We place it before the registrar.
It has the approval of the government, then all
Yes,
right.
it has. I have the original report.
We are not disputing the government bringing the circular. Whether the circular is a law is an issue. That's what.
You will get your chance.
Yes.
In a different context, Lordship.
All right, brother. So now we have come to that end of that, your second point of argument.
Yes, that it is not an essential religious practice. The second limb of that has to be substantiated.
Yes.
The burden has not been discharged, is what we have submitted. But an independent reading of Quran would also show that I will be in a position to show.
We'll continue tomorrow,
Tomorrow, right now.
2:30. The arguments.
One submission. This court also passed the order in 3853. I am also producing the memorandum of association also for recording. Because court has said bylaws.
Registry, they have, so that we have a copy
Can
of
we take the documents
No, I
like?
have given a copy. We are given a
We
copy.
will not take any document in the court.
Yes.
We have made a
have filed
procedure
it.
now. Please follow that
No,
procedure.
we have filed it in the,
Yes.
given the memo also.
The learned advocate general has placed his arguments. He is continuing with his arguments. Put up tomorrow at 2:30.
Please, Your Lordship. Please.
Tomorrow I may be given some 10 minutes time. Given. 1.6. Please. So the 141 section